Now, what he would do about people who fornicate on the beach, I don't know. But nonetheless, he spun this web. And that was it. So they held the statute unconstitutional, even though the legislature, two bodies in Connecticut, had enacted it, and the governor had signed it. In other words, this was democracy in Connecticut, like it or not. He invalidated it. Okay, that was bad enough. Now comes Roe v. Wade with 50 states, every one of the states in this so-called federalist system with a national government and constituent states, every one of which has some kind of law inhibiting in some way or other abortion. Now, put aside whether you approve of that or you don't approve of it. The fact of the matter is that those laws were there. So drawing on, building on, utilizing as a precedent even, Douglas's ersatz right of privacy, they said, oh, well, we've already decided that there is such a thing as privacy, quote, end quote, and what could be more, quote, private, quote, than the abortion decision. So all of these 50 states' statutes are unconstitutional. Now, we're supposed to be in a federalism system where there's a national government that has its sphere and state governments which have their sphere. So the federal Supreme Court wiped out all the state statutes. We're also supposed to have a system of separation of powers. So in that decision, as well as Griswold, we find a federal court deleting statutes enacted by state legislatures. So we not only find in Roe, for example, and I'm not obsessed with this, but it's just a good example, we find in Roe a terrible violation of federalism, a terrible violation of separation of powers, right? And a decision that affects countless millions of women and unborns, based on not even sand, air, in the Griswold decision. Now, I don't expect somebody at a Tea Party rally or protest in front of their congressman's office to be able to explain this to this ninny, but at least if they know it and they understand it, they can make some kind of an argument or form some kind of a question.
Really what you're describing is the sweeping powers of federal government that have extended their powers and are taking powers over from the states. Is that what you're saying?
Yes. I mean, the 10th Amendment says, to paraphrase, that if a power is not explicitly delegated to the federal government in the Constitution, or in the Constitution prohibited to the states, and there are very few of those, like impairment of contract, they are reserved, respectively, to the states or the people, and the people. So that's what a federal system means. But you'd never know it. I mean, for example, the Interstate Commerce Clause has been interpreted to allow the federal government to control a railroad that never left the borders of a given state. It was an intra-state railroad. What did the Supreme Court decide? Way back in the 30s. What did it decide? It decided it affects interstate commerce. Well, what doesn't by that standard? And if there's nothing that doesn't affect interstate commerce, then under the Interstate Commerce Clause, Congress can pass laws affecting anything.
In my interview with Edwin Vieira, he was talking about the Commerce Clause. Is this the same thing?
Yes, exactly.
So there's a portal very much like executive order can bypass everything.
Well, to a considerable extent, yes. I mean, Carter issued an executive order that said any American claims against Iran after their revolution in the 70s had to be settled by a commission that was to be set up and not and disallowed any affected Americans, individuals, or companies to sue in court. And that's a whole other ball of wax, whether or not by executive order the president can circumvent the treaty requirements.
After 50 years, where do you stand right now, watching the history and everything you've watched related to the founding documents?
Well, I mean...
What is it like to be you, knowing what you know, being in practice?
It's an excellent, and I take it as well, a sympathetic question. It's very, very difficult. It's very, very difficult. I mentioned previously that in an earlier conversation you and I had, that my last book was on the first 15 terms or years of Justice Thomas, Clarence Thomas. It's called The Supreme Court Opinions of Clarence Thomas, 91 to 06. Thomas is an originalist. He reads the Constitution, and that's what it says, so that's what it means. If it's not clear what it means, he looks to see what it meant to the people who wrote it. So one of his, I was going to say favorite subjects, but I guess it's unfavorite subjects, is what's happened to the Eighth Amendment provision, which deals with cruel and unusual punishments. And as the word punishments makes very clear, what that was designed to do was to prevent punishments which were cruel and unusual, like drawing and quartering somebody, etc. Well, that clause, that provision, has been so perverted that it gave rise to a whole new field of law, which is peopled by practitioners of the left, dealing with the so-called prisoners' rights. So if somebody gets sent up the river, and he's a vegan, like I am, and he says to the warden, I want vegan food. And he says, well, you can't have vegan food. We feed everybody the same way. I mean, you eat it or you don't eat it. That's how it is. Oh, no, he says, I'm going to call the ACLU, and they're going to start a lawsuit, and they're going to claim that under the federal civil rights statute, you're violating my, quote, Eighth Amendment right not to be free of cruel and unusual punishment. In other words, it's cruel and unusual punishment under the Eighth Amendment and the Federal Civil Rights Act not to give me vegan food. Figure it out. I can't eat meat, poultry, fish, dairy products, or eggs. So you figure out how to do it. Or I have a right to wear a beard as a Muslim in a high-security prison where I could hide a weapon or something. Or a yarmulke if I'm an Orthodox Jew, or whatever. Or not to have conjugal visits. Or, believe it or not, there was a case that said there weren't enough tables in the prison law library, and the hours weren't long enough.
That's wild.
Can you imagine this?
That's really wild.
No, but it's infinitely worse than the specific case. What's worse is that this kind of I wouldn't even deign to call it analysis, that this kind of or thinking for that matter, this kind of something could pervert and poison and corrupt a constitutional amendment that was in the original Bill of Rights. Now, if that's possible, if the Eighth Amendment, which bespeaks against cruel and unusual punishment, can wind up through a bunch of interpretations by succeeding Supreme Courts to mean that virtually anybody in prison can complain about virtually anything, whether they succeed or not, we have come a long, long, long way from the original understanding. And you ask me, how does that make me feel? It makes me feel terrible. And it makes me feel pessimistic, pardon me, and it scares me.
I have something that scares me that I want to talk about, and it has to do with the language being used to describe the Constitution as being a living, breathing, changeable, malleable document. Have you heard that?
I've heard it, and I've written about it, and there's a lot on that in my book about Justice Thomas, of course. And it comes, I mean, the high priest of that was William J. Brennan, Supreme Court Justice, by the way, appointed by Eisenhower, Republican, as were other appointments by Republicans, like Souter by Bush 1, and Kennedy by by Reagan. What they have done